Are you going to find that in legislative history? For one thing, in a multi-member body, it's very hard to understand what the intent was beyond the words that they all voted on. Other than that, they could have voted for them for very different reasons. Just because one or two of them say, oh, I think the language does this, the rest may not have felt the same way. So the notion that you can pluck statements from a couple of legislators or even from a committee report, which is usually written by some teenagers and not even
members of the Federal Society, if we're lucky.
Not even very often, not even read by the committee, much less read by the whole House, much less read by the other House. The notion that somehow is reflective of the intent of the whole Congress and of the president who had to sign the thing. I mean, it truly is the last surviving fiction in American law. There would be a lot of fictions, you know. This is a fiction. You should interpret them not to cover the things that the people who adopted that provision did not think they covered. And, you know, cruel and unusual punishments is one. Of course, those words could cover a lot of things, but it's clear from the history of the times that nobody thought that it included the death penalty. Nobody. And it's the same thing with this right of abortion, whether it's founded in the 14th or, I mean, God, the 9th Amendment, forget about it. Nobody ever thought that, I mean, just look at history. All the states had prohibitions on abortion for hundreds of years. So when was it that the American people made the decision to forbid a state from adopting such?
They never did.
They never did. The court made it up. And you know, we're not talking about the right or wrong of the substantive result. I mean, I'm quite, you know, neutral on that.